Coming up next on Arizona Horizon, it's our U.S. Supreme Court midterm review with Professor Paul Bender from Arizona State University's O'Connor College of Law. A Supreme Court review next on Arizona Horizon.
Arizona Horizon is made possible by contributions from the Friends of Eight, members of your Arizona PBS station. Thank you.
Good evening and welcome to Arizona Horizon. I'm Ted Simons. Congresswoman Ann Kirkpatrick today announced her candidacy for John McCain's U.S. Senate seat. Kirkpatrick currently represents Arizona's 1st congressional district. Kirkpatrick says that the economy will be a key campaign issue in her Senate campaign and adds that while she respects John McCain's service, Arizonans should, quote, have a real choice in who they send to the United States Senate. The U.S. Supreme Court has about a month left in its current session. Here now with a midterm update of the bigger cases the High Court's considering is ASU law professor Paul Bender.
Hi,
How you doing? Good to see you.
Good to see you.
Thanks for stopping in.
Yeah, anytime.
Got a lot to talk about.
Yeah, oh yeah.
Before we
There'll
get to
be
this,
even more to talk about next month.
I would imagine, yeah. Before we get to the specifics, we got 5 cases in particular we want to look at. Let's talk about the tenor of the session so far. Any surprises? Anyone doing things you didn't expect?
It's a little early in the session to have a tenor. You know, they still have 25 cases left, which is more than a third of their caseload. So everything gets backloaded, and the most important cases tend to come down in June. They handed down 3 opinions today, but they were not important cases. So I think it's too early to have it. The cases we're going to talk about are really the ones that are going to establish what the tenor of the session is.
But we can still say it's a Kennedy court?
Until proven otherwise, yes, you can still say it's a Kennedy. Every once in a while, Chief Justice Roberts makes noises as if he might turn into a swing vote, but they're just noises. He doesn't really continue in that direction, but he could at any time. Any one of these cases, which would divide 5 to 4, he could, as he did in the one time he's ever done this, side with the liberals to change the result was the Obamacare case, and he could do that again, but he hasn't done it since.
Well, let's get to the cases here. We talked about Representative Kirkpatrick now deciding to run for Senate. Some think she's doing that because she anticipates the U.S. Supreme Court as coming down on one side of the Arizona legislature as far as redistricting. In other words, they're not going to draw a nice map for her next time around. Let's talk about this case.
If they get a chance, it's a really interesting case. As you know, the people of Arizona decided to take the districting of both the state legislature and the congressional seats away from the legislature and put them in the hands of an independent redistricting commission, which is not elected. It's appointed through a merit selection process, really. And it's 2 Republicans, 2 Democrats, and 1 independent is the tiebreaker. And the first time they redistricted, nobody seemed to think there was a problem with what they did with the congressional districts. But the second time, a new commission each 10 years, the second time they came up with 3 really competitive districts, and Democrats won all 3 of them. And so you had Democrats with 5 of the seats and Republicans with only 4. The only thing that's involved in this case is the congressional seats. Right. Nobody is challenging, and they can't challenge the fact that the commission, I think, will continue to do the state legislative districts. But they found something in the Constitution, the U.S. Constitution. It can't be in the Arizona Constitution because the Independent Redistricting Commission is in the Arizona Constitution. But the U.S. Constitution says the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. And so the legislature reads that and says, hey, we're the legislature. And so the Independent Redistricting Commission has no right to prescribe the districts for Congress, and that's what this case is about. And if you take a straight literal interpretation and it says legislature, well, that's the legislature. That is not as clear as it might seem, and I'm hoping it's not as clear as the Supreme Court might construe it. In Arizona, the legislature is really the people, because the people have, the Arizona Constitution says the people can veto anything the legislature does through referenda. The people can pass any law they want, and the Constitution goes out of its way to say, and the people can do that despite what the legislature wants. So the people in Arizona are really the last word in the legislature. So when it says the legislature here, it really in Arizona should mean the people.
But why doesn't it say the people?
Because in those times, nobody had the kind of direct democracy we have. We're talking about 13 states. We're talking about the original Constitution. There were no referenda and initiatives in the original colonies. So the legislature there was, in those states, was the only legislative authority. But in the West, as time went on, we have more and more of this direct democracy. California has it, we have it, Washington has it, Oregon has it, and California has a commission like ours. Washington has a commission like ours. They all filed amicus brief telling the Supreme Court that, hey, in these states, you have to give the people the ultimate power. And that's really the issue before the Supreme Court, is whether they're going to read this legislature to say the formal legislature, or whether they can read it to say the people or whoever in that state has the legislative power. And if that's the question, then the answer is, in Arizona, it's the people, and the people adopted the commission.
And yet, most folks, and I think you're included here, you don't think they're going to take that. You think they're going to read that literally.
My guess is, yeah, that they would do what I consider to be the wrong thing. Because you can't think of, at least I can't think of, a reason why anybody who drafted the original Constitution would want to stop the people of a state from saying, we don't want our legislature to redistrict, because we know what they do when they redistrict. The first thing they do is protect themselves, so every incumbent has a safe seat. And the second thing they do is to gerrymander the thing to help whatever party is in power. And the other thing they do in Arizona is not to have competitive districts. There are all these safe seats. So if the people of a state want to change that and make it different and less political, more neutral, why would anybody writing a federal constitution want to stop them from doing that?
If the legislature wins this argument, what happens in Arizona?
Well, that's a good question. They will probably, I would assume, go into special session over the summer or maybe in the fall. I don't know if they wait to January, because there's an election coming in 2016. So the legislature, if the Supreme Court gives them the right to draw the districts, I think would want to draw the districts to make sure that they're in place in the 2016 congressional election, which may have something to do with Representative Kirkpatrick deciding to get out of that district. But the legislature could have a special session and pass a new redistricting plan, which would probably favor Republicans, because that's what they do. That doesn't mean that that is going to be used in 2016 or even 2018 or even 2020, because if the legislature does that, the people in Arizona, remember, have the last word. The legislature can only stop a referendum if it has a 2/3 vote. They're not going to pass a redistricting plan by a 2/3 vote, because the Democrats have enough time. So anybody could get referendum petitions to put what the legislature does on hold. That would mean that the present districts would stay at least into 2016. And then the people, if they got enough signatures, the people would have a chance to decide whether they wanted to adopt the legislature's thing, or whether they wanted to go back to what the Independent Redistricting Commission
And that would get around this case should the court side with the legislature? Because again, the Article 1, Section 4, whatever it is in there, it's saying legislature has to do this.
But in Arizona, the people can undo anything the legislature does, and the Supreme Court's not going to quarrel with that. So if the legislature passes a new districting, and if enough people sign referendum petitions, that'll put what the legislature does on hold until the 2016 election.
This will have
it gets
political
enormously complicated.
This have political races running in circles. They won't.
Well,
they don't know
that's
where
the
to go.
problem, you know, because if the legislature may start fighting with itself, you got to know what the districts are in time to decide where you're going to run, or where you're going to move, so you can live in a district that you can win in. So yeah, that's going to have a big effect on Arizona if the court does what most people think it's going to do.
Okay, we got to keep it moving here now. The next one is King Burwell. This is the Obamacare case. Talk to us about this.
That's really important. It's a fluke. Again, it's a question of whether you read the words of the statute here. It's not a constitutional case without thinking about what the words really mean. The Obamacare statute set up the way Obamacare is trying to achieve its intended result of getting as many people covered by health insurance as possible. There are several different things they do. One is to expand Medicaid, so more people are covered by that. And another one is to make it easier for people to buy health insurance from private companies on their own. And so what it does is it permits states to set up healthcare exchanges in the state. And if you buy on the exchange, you're supposed to get a good price. And the statute says if you can't afford it and you buy on an exchange, the federal government will subsidize you. And there's a lot of money in those subsidies. I think everybody in Congress probably assumed that all states would set up their own exchanges, but that hasn't happened. I think only 16 or so states, most states have not set up their own, and Arizona has not. The Obamacare statute, when it talks about subsidies, it says subsidies go to people who get their insurance on a state exchange.
Yes.
So the people who have brought this lawsuit are saying in those states like Arizona that don't have a state exchange, they have a federal exchange because the statute says if the state doesn't want to do it, the federal government's going to do it instead. But the argument is, well, that's not a state exchange. So that the states that have not established their own exchange would lose all those federal subsidies for the people who are now getting them in order to get them to be able to have health insurance. And if that happened, and Arizona persisted in not having its own exchange, we would lose an enormous amount of federal money. A lot of people would lose their health insurance, rates would go up, it would be a disaster.
But you mentioned, and if Arizona does not establish its own state exchange, isn't it in the Constitution now that we can't establish?
Yes, it is.
So that's ball game. That's out the window.
Well, I'm not sure that constitutional provision is constitutional.
Okay.
Because federal law is supreme. And if federal law says a state can establish an exchange, I'm not sure that a state has the right to disable itself from doing what federal government wants to give it the power to do. But that could be possible. And then Arizona would be stuck. They would be stuck with not getting any federal subsidies for these people. So the people are either going to go without health insurance or they're going to have to spend an enormous amount of money on it. A lot of people are going to become uninsured. A lot of money will not come into Arizona. It'll cost the state a fortune to take care of those people, and rates will go up because if you narrow the people who are insured, if the base of the insurance scheme gets smaller, then rates tend to go up. So it would really be a very, very disastrous thing for Arizona.
What do you see the court doing in this case?
Again, I think in this one, I'm going to guess that they will hold that a federal exchange is a state exchange for purposes of that provision, because what the federal government is doing is substituting for the state.
Right.
That's the argument that's being made. When the federal government puts an exchange, it really is a state exchange. It's just a state exchange that the state decided not to do, so the federal government will do it for the state. That's an argument that the court could adopt. And my guess is that they will, because I think it will dawn on them finally, even if they don't like Obamacare, like Justice Kennedy is, who we're talking about here. Mm-hmm. He doesn't like Obama. He voted against it. But he has to realize that this would it would really destroy the system. It would make no sense at all. And that, I would think, would make him think twice about doing that. And because it's clear that Congress intended these subsidies to be, that was one of the main ways that Congress was going to get more people covered, was if you couldn't afford it, we will subsidize you depending on your income. So if Congress intended that, why would they only want to do that in states that decided to set up their own exchange? Why wouldn't they want to do that in the entire country? And unless you can come up with a good reason why, then I would think that the right thing to do is to say an exchange is a state exchange.
But that last argument you made, are we overlapping into states' rights arguments there?
Well, yeah. Sure, yeah.
Okay,
yeah.
So that may be one of the, okay.
Yeah.
Let's keep it moving here. Same-sex marriage, we've talked about this before now. Same-sex marriage, these 4 cases wrapped into one, whatever here.
Right.
Where are we at this, and what do you expect out of this?
Where are we as they've been argued? And this time I assume they're going to decide them. Last time they had it before them, a few years ago, they got out of it. They had the California case and they decided they didn't have jurisdiction. But I think this case they're going to have to decide it. And every federal court but one that has considered the issue, since the Supreme Court decided that the Federal Defense of Marriage Act was unconstitutional, has held that there's a constitutional right to same-sex marriage, that you can't have marriage restricted only to heterosexual couples. And Arizona, as you know, has a constitutional provision which says marriage is between one man and one woman. So if the Supreme Court were to hold that it's unconstitutional under the federal constitution to prevent gay couples from marrying, that would wipe out the Arizona constitutional provision, and we would have gay marriage in Arizona and in every other state. I think that's the likely thing to happen because a couple of reasons. One, the court had a chance to take this issue and didn't. And in not taking it, it let gay marriage go into effect in several states, and many thousands of people in those states have gotten married, gay couples have gotten married. Then the court decides to take this case after they let that happen. I would think it's very unlikely that the court would, having let gay couples marry under decisions that held that they had a constitutional right to do that, to turn around and say, sorry, we didn't tell you that, but when you got married, you didn't have the constitutional right to do that. I think the court would be really reluctant to do that.
Broad, narrow ruling, what do you see here?
I don't see any way to do a narrow ruling on that. There are two issues in the case, and the second issue is if the court should decide that there is no right to gay marriage, that states do not have to have it, what should happen when one state has it and people who are married in that state move to another state like Arizona that doesn't have it? And the court could decide, that's the only compromise I can see. You don't have a right to gay marriage, but if a state wants to let you marry a same-sex couple, then every other state has to recognize that marriage. Yeah. That would be a nightmare.
Is this likely to be the landmark ruling, you think, of the session?
Yeah. Well, I think most people would think that it is, although I think in terms of practical importance, whatever the court does about gay marriage, in 15 or 20 years, virtually every state will have gay marriage. I mean, clearly the way things are going. So in that sense, in long-term consequences, I don't think it's nearly as important as, say, the Obamacare case, where if the court does what the plaintiffs in that case want them to do, it will really destroy Obamacare's effort to get everybody covered by insurance, something that's been working.
Yes.
And I think it could destroy it for a long period of time.
Yeah, something that's been working to some, but others saying it was unconstitutional. Well,
right.
argued
No,
from the
I'm
beginning.
working in the sense of people are getting insured. I don't know how many million people are insured who weren't before.
Another case that involves, a lot of these things involving Arizona one way or the other here, this lethal injection case, where do we stand on that?
That case is not from Arizona, but it's as if it were. It's from Oklahoma. But what's happened is, after lethal injection came in, the states that retained the death penalty all used, I think, the same cocktail of drugs to inject, and it seemed to work well. But the first of those drugs, which is intended to render you unconscious so you can't feel the enormous pain you would feel if you weren't rendered unconscious when they put the second and third drug in, which is to stop your heart and to stop you from breathing. The drug that everybody was using to render you unconscious became unavailable, because the people who made it didn't want to sell it to states that wanted to use it to help kill people. And so the states had to find another drug. Well, a number of states, Arizona included, found this drug which Oklahoma uses. And the first time they tried to use it, it was a disaster. It took a long time for the person to die. And that even happened in Arizona, I think. So 16 or so people on death row in Oklahoma brought a suit saying it's cruel and unusual punishment to subject us to that, because there's a good chance that we will suffer. Justice Kagan at the oral argument said it would be like being burned alive if that doesn't work. So what the court has got to decide is what to do about that. It's a real problem, because how do you know, how will you ever find out what happens to these people if they're rendered so that they can't, if they're paralyzed so they can't talk, they could be suffering enormous pain, you'd never know it, and then they'll die. How do you know whether that happened or not? And the surface of it, they could look perfectly calm. So what the plaintiffs are saying is, hey, until you're sure that the drug you're using is going to work, you can't use it.
That's what they're saying.
That's what they're saying.
What happens if the court says that this doesn't cut it? Do we have to find new ways of putting people to death? What is the result of this?
If the court were to say that the plaintiffs are right, that you can't use that drug, the plaintiffs, the defendants, the inmates are right, that you can't use that drug unless you can prove that it is going to be effective in rendering you unconscious, then the states will be put in a very bad situation. The states want to have the death penalty. They'll have to find something else to do, and it's very hard to find the drug. They've tried, and they haven't. So some might go back to the firing squad. Some might go back to the electric chair. Some might decide to get rid of Nebraska, for example, just decided. So the court's decision in that case, if it were to decide that these people have a good case and that it might be cruel and unusual punishment, that would have the chance of maybe starting the death penalty debate anew again, and maybe getting some states to change what they do.
With that in mind, again, broad or narrow ruling?
That one, I think, is like, again, it's somewhat like the gay marriage case where they let people get married. I think they're not going to say, hey, we shouldn't have done that. Well, here, they were asked to stay all of these executions of the people in Oklahoma. The first person who was going to be executed asked for a stay of his execution. They denied it. He was executed. He was raising exactly the same point that these people are raising. If they denied it for him,
Right.
then it would seem to me that they're really not prepared to stop the other executions. So my guess is that they will let the states continue to use that drug unless somebody can prove that it clearly is an unsatisfactory drug and people are going to suffer enormous pain.
Our last case that we want to look at here, this one does have a direct impact on Arizona and the town of Gilbert, this street sign ordinance deal regarding First Amendment, religious issues, the whole 9 yards. This is an interesting little case.
It's very interesting theoretically. I don't think it's all that interesting practically, because the issue in the case is, can a city constitutionally have different rules for political signs different from the rules that it has for event signs? What's at stake here is there's a small church that has they don't have their own church building, so they do it in schools that on Sundays, and they rent them out, and they have their services there. Well, they advertise where the thing is, and they put up a sign. And the Gilbert ordinance says event announcement signs can only be like 2 feet square, and you can only put them up 12 hours before the event. You got to take them down an hour after the event. Political signs, like vote for me for Congress, can go up months before the election and can stay for a long time after it and can be 20 feet wide rather than just a foot wide. So what the church people are saying here is that's unconstitutional. You're treating two different signs differently based on what they're for, what the content is. And that raises what has really been a problem in the First Amendment for years, is that the court keeps saying content discrimination is not constitutional unless you have an overpowering reason. So the question in this case is, if you treat event announcement signs differently from political campaign signs, is that a content discrimination?
Can it be argued, though, that the event of regarding the political signs is an event until Election Day?
I think that's why they let those signs stay up for a long time, and it makes sense to let those signs stay for a long time. If you're announcing a Sunday service, it doesn't make any sense to leave that sign up any longer than after the service. So I'm sure the city has good reasons for doing this, but if that's treated as content discrimination, the city is going to have to come up with more than a good reason. They're going to have to come up with a really good reason.
Could the church say services every Sunday from now until December 25th, and it has to stay up there because the event is the biggie on December 25th?
They could try to do that kind of thing. I don't know if they get away with it. They would have to try to get it under the definition of political sign rather than event sign.
Gotcha. This was argued way back in January.
Yeah, that's interesting.
What's that all about?
It's the third oldest case the court has. That is, they only have 2 cases that were argued before this one. What's going on there? I think what's going on there is so complicated from the First Amendment perspective, and the court has, pardon me for being disrespectful of the court in this area, but the court has really messed up that area. So it's virtually incomprehensible what they've done, and they're having trouble figuring it out. And very possibly there's somebody who keeps changing sides, doesn't know what side he or she is going to come out on. So I think it's going to be a really fractured decision. There may not be an opinion of the court, which will make things even worse, because without an opinion of the court, you don't know what the answer is. It seems to me the court's gone off on the wrong track here by making things turn on whether there's a content discrimination. That's not what should be important for the First Amendment. What should be important if there's a viewpoint discrimination. If we treat you better than we treat me because we like your message and we don't like my message, that's really a no-no under the First Amendment. But if you treat political signs differently from event signs or from ideological signs, which just say about an ideology rather than a candidate, what's so dangerous about that? That's not taking sides in a debate. Right. It's not censoring anybody's views. So I would approach it not in terms of content discrimination, but in terms of viewpoint discrimination. The court has not done that.
We got about 30 seconds left. Of these cases, which do you see decided the quickest? The earliest.
They all could be decided on the last day of the term.
Or they could be tomorrow.
No, I don't think they
You don't think it could be tomorrow? Okay.
Next week they could be. Yeah, I would think that the gay marriage case is going to be at the very end of the term. And I would think the Obamacare case is going to be at the very end of the term.
Two biggies.
Yeah.
All right. Wow, great stuff. Always a pleasure. Good to have you here. Thanks for joining us.
Nice to be here today.
And Wednesday on Arizona Horizon, we will take a closer look at Representative Ann Kirkpatrick's decision to run for John McCain's U.S. Senate seat. And we'll hear about efforts to improve teaching skills through professional development. That's at 5:30 and 10 on the next Arizona Horizon. That is it for now. I'm Ted Simons. Thank you so much for joining us. You have a great evening.
Arizona Horizon is made possible by contributions from the Friends of Eight, members of your Arizona PBS station. Thank you.